會議呢，而家係
Well, let's resume the meeting. We're on item 7. Assessment of the statutory compensation of resumed properties and resolution of disputes arising from land resumption. So may I first of all welcome representatives from the government attending this meeting. The attendance list is in front of you. I won't go through them one by one. Perhaps I'll invite the administration to briefly walk us through the item, please. Thank you, Chairman. Well, sometimes the government may need to rely on the relevant laws to resume landed properties to facilitate public works projects. Now, the most cited ordinance is Cap 124, Land Resumption Ordinance. And according to the ordinance, the owner affected may seek compensation from the government and at a level set by the Lands Department in accordance with the relevant laws and the common law principles. And if the affected owner does not agree with the amount, the case may be referred to the Lands Tribunal for a final decision. And in the course of that, the owner can engage a professional to give expert advice. The Lands Department will also negotiate with the owner on the basis of the expert advice given. And according to the law, the fees may be reimbursed for professional fees made. And members may be concerned about the redevelopment value of properties when the assessment is made, and in relation to the handling approach for different types of properties, that is with a single owner title or with multiple ownership. In fact, we adopt the same principle or approach. The Lands Department will base its assessment for statutory compensation on the open market value. Basically, since the owner for single ownership, the owner has the sole right to decide whether to allow redevelopment by a property developer, and the government will compare the redeveloped value with the open market value, and the higher level will be adopted as a statutory compensation amount. As for property held under multiple ownership, that is, the assessment will be based on the value for existing use, and in accordance with the common law principles and other case laws, if there is evidence to show that at the time of the land being or the property being resumed, there is value for redevelopment, the Lands Department will assess the redevelopment value, and a comparison will also be made between redevelopment value and the existing value, and the higher value will be adopted as a statutory compensation for owners. If members are interested, we can further elaborate on the above said point. Members may also be concerned about a dispute resolution arising from land resumption in the compensation process. As said just now, if the affected owner does not agree with the proposed compensation amount, a professional independent of the Lands Department can be engaged to give legal advice, and the reasonable fees can be reimbursed by the Lands Department. This arrangement may allow affected owners to have access to professional help. If the Lands Department and the owner in the end cannot reach any agreement, the case can be referred to the Lands Tribunal for adjudication. We believe that this system is well established and effective, and the reimbursement of professional fees arrangement may also facilitate the owner in getting professional help. And The Lands Department will also give consideration to cases on their own merits on resolving disputes. And one of the factors is that the agreement reached or the outcome of the dispute resolution should not affect the Lands Department's right in exercising its power. Next, I'd like to invite Mr. Christopher Seabrook Mills to say something about the operational matters. Yes, Mr. Mills, please.
Thank you, Celine, and good afternoon, members. I think basically the paper sets out most of the points quite succinctly, and I think Celine's introduction covers some of the major items. But I just want to supplement a few things for members' particular attention. The principles underlying compensation payments in Hong Kong come from the common law through the courts and also from statutory provisions, and that therefore provide limits as to how flexible and how the compensation claims can be treated. They must follow the law and the statutory requirements. The principle of equivalence is basically the fundamental principle underlying compensation. This is something which it governs the right for the owner to be put in the same position as he was before the resumption in financial terms, and that not to be compensated more so, but the equal amount, not to suffer a loss. Another principle arising from the law is what is referred to as the point Gord rule, where compensation cannot include an increase in value brought about by the scheme. Under the Land Resumption Ordinance, there are various provisions which control the method in which the compensation payment should be assessed. And it's basically the open market value, which is that value expected to be realized by a willing seller in the open market, subject to various considerations not being taken into account and some other conditions being taken into account. They're itemised in the paper, and the copy of the Land Resumption Ordinance is also attached. The Lands Tribunal, Celine mentioned, is, I think, worthy of particular attention, because the subject today is also including mediation and methods to resolve disputes. Already the existing mechanism of the Lands Tribunal is set up under the Lands Tribunal Ordinance. And it needs to be noted that the Lands Tribunal is composed of professional judges, 4 of them, and also 2 professional qualified surveyors. So the hearings are conducted very much the same as a court proceedings, and they come up with a decision which is fair to both parties. And under our land resumption and compensation regime, the claimants have the right to take their case to the Lands Tribunal if they are aggrieved. The open market value, this is provided under the Land Resumption Ordinance, and in most cases this would be to compensate in terms of the price paid for occupation or rental received for a property, which would be the existing use value. If the ownership of the property is single ownership, the single owner obviously has the option or the opportunity to proceed or explore redevelopment, and we would assess a redevelopment value, and whichever is the higher would be offered. In some cases the redevelopment value may not be higher, it's not automatic, but we would assess it on both bases and then offer him the right, the highest amount. The Court of Appeal has also ruled on this redevelopment value and how it should be assessed. The test would include whether, on the balance of probabilities, the evidence points to redevelopment of the property being very likely. This must be demonstrated by actual proposals and evidence, and regard would be had to developments taking place in the vicinity, and that the development would be reasonably likely within a reasonable time frame. So we would take all these things into account in determining whether redevelopment was actually a feasible option. The single unit, the EUV would be offered unless the likelihood of redevelopment is so proven. And in terms of, I just quickly want to refer to the dispute resolution aspect of the discussion today. Lands Department, we haven't so far adopted this. We're prepared to look at it. And I think government has replied to the Honourable Albert Chan in a previous Legislative Council question back in March 2014. And the entitlements and the procedures and bases are set out in the relevant ordinances, and we're obliged to follow those principles, so that the scope of those items which could be mediated is actually quite limited. The Legislative Council, the Research Office papers were very helpful, and I'd like to thank the Research Office for their efforts in producing these information notes. It was interesting to note that there are many similarities amongst the various jurisdictions, despite the fact that these jurisdictions are extremely different in other ways. Economy, culture, social responsibilities, all that kind of thing. But there were many similarities came out. And but the research papers, one thing they didn't refer to was the aspect of property held in multiple ownership, which I think in Hong Kong is perhaps not necessarily unique, but a particular issue. These other jurisdictions, perhaps the multiple ownership issue is not so prevalent. And it may not therefore be appropriate to compare Hong Kong directly. It's right that everybody should follow certain principles, but each jurisdiction must have its own peculiarities. As I said before, for resumed land and buildings held by a single owner, RDV would be assessed, redevelopment value would be assessed, and the higher of the amount between that and the existing use value would be offered to the claimant. Before winding up, I just want to also make reference to our the Lands Department's Land Resumption and Compensation Guideline for Owners, Occupiers and Surveyors, which is a booklet which we produce, which is available on our website. It's given to all potentially affected parties. And surveyors. It covers all aspects, including domestic properties. It talks about existing use value. It talks about redevelopment value. It mentions home purchase allowances, the appeal mechanism, commercial properties, and then it ends up, also the Lands Tribunal is made reference to, and it ends up by giving a contact in our acquisition section for further queries and offering our further advice and guidance. So I think claimants and practitioners have a good basis in this document to know what is involved in the resumption of the properties and how to go about taking action to make a claim and also to appeal against the government. I think, just in conclusion, I think it's, as we said in the paper, subject to the nature of the issues that are in dispute and whether mediation may enhance the prospect of resolution. Lands Department is prepared to consider mediation, and in fact this was spelt out by Secretary for Justice last year in a written reply to a LegCo question. And we're prepared to consider such requests on a case-by-case basis, rather than, at this stage at least, introducing an across-the-board scheme. And in fact, there are, I believe, 1 or 2 cases already where we're reconsidering cases and the option of mediation is not excluded. We would obviously need to take up cases with Department of Justice and look at the rationale and the feasibility. I think that's really all I want to say. I just wanted to highlight the main points. I'm here today with an assistant director from acquisition and also a chief estate surveyor for valuation. So if there's any queries, we'd be happy to help and try and reply to our best.
Thank you.
Thank you. Does any member wish to ask question? Mr. Wu Chi-wai, 4 minutes questions and answers. Thank you, Chairman. Now, on this topic, I've read the government's papers. I think the major controversy lies with the fact that in assessing statutory compensation for properties held under single ownership, the open market value will be gauged against the redevelopment value, and the higher amount will be adopted as the statutory compensation amount. As for individual owners, they find themselves having limited choices. It's hard for them to reach an agreement to develop the properties held under multiple ownership. So there is nothing like the redevelopment value as such, and only the open market value will be considered or assessed. I think in the minds of many small owners, they find this unfair because, right, of course, this is also a fact that for single ownership, the owner may have more options. They can either lease out the property or sell it. For smaller owners, however, they can only probably use the property by themselves. But I wonder if there are other options. For example, in older districts, very often they face the issue of redevelopment. So, of course, this is not yet happening at the moment. But let's say if land is to be resumed in a certain old district, and in making assessment because the property is held under multiple ownership, the redevelopment value will not be assessed.
So that will give people the impression that well, there will be a large discrepancy, because if the entire district is subject to redevelopment, and if it's happening in a neighborhood, and still you're not going to calculate the redevelopment value, in that case, then that's not fair. Well, in areas with a high redevelopment value, then whatever you do, so whether you're talking about one single owner or multiple owners, well, the situation should not differ too much, because as you said in the paper, you would not consider allowing them to modify the land lease for the purpose of redevelopment. That's the existing practice. That will not be taken into account. In other words, for example, if I own a piece of farmland, and if I rezone it, then I can redevelop it into a residential development, but then that would not be taken into account, right? So if in the community there is redevelopment value, but then if you tell me that under the existing arrangement, well, if it's a single owner owning the entire block, then you would consider the redevelopment value. But then if it's under multiple ownership, then that will not be considered. I think that's an unfair practice. So can the administration respond to that? Because just now, from what I've heard, you said that you talk about multiple ownership or scattered ownership, and one of the considerations is the possibility of a redevelopment. So the number one factor that they will consider is whether or not there is any potential for redevelopment, and then they will look into the redevelopment value and also the differential between the RDV and the EUV. So the higher will be adopted as the statutory compensation. So Mr. Wu Chi-wai asked the question just now. So which one of you can respond in greater detail about the existing practice? All right, thank you, Chairman. Concerning the question raised by Mr. Wu, and as the chairman just pointed out, in calculating, well, let's say if it's a landed property, whether or not it's under single ownership or multiple ownership, if there is a redevelopment value, and if there is sufficient evidence to prove that there is redevelopment value, then on the date of resumption, if there is a possibility of redevelopment, then the lands department will do both calculations. One, it will look into the existing use value, and second, as Mr. Wu just suggested, if there is a higher chance of redevelopment, then they would also be looking at the RDV, and that would also be calculated on a case-by-case basis. And if the RDV is higher than the EUV, then of course the higher will be offered as compensation. But then if it's under one single ownership, the basic consideration is, as mentioned just now, he will have a whole or sole control of the property. So there is an assumption that there is this redevelopment value. But then if it's under multiple or scattered ownership, then there needs to be sufficient evidence to prove the redevelopment potential. And that has to be based on objective circumstances and objective facts. And that would also be considered on a case-by-case basis. For the details, can I invite Mr. Mills to supplement on the principles and also the details? I think members are all concerned about this. That's why I think we can spend more time on that. So, Mr. Mills, can you tell us more? Because just now, one point was also mentioned. There were some cases or case laws, in particular, where there is multiple ownership, then the redevelopment potential or possibility, how high is that? And as Mr. Wu said, if it's urban renewal cases, all right, on land resumption, according to my understanding, one of the considerations is that, well, yes, it's going to be redeveloped. The reason why they have to resume the land, because in the open market, when they try to collect all the undivided shares, they have not been able to do that after years of efforts. Well, in the past, according to my understanding, that has been the case. So, Mr. Mills, can you explain a bit further on that for us? Can you give us some advice?
Thank you, Chairman. I think obviously each case needs to be looked at on its own individual merits with the facts and everything that speaks to that case. The basic principle is, the basic compensation principle is, as I said before, the equivalence. The owner of the premises, whether he be a single owner or a multiple owner, is entitled to compensation in accordance with his interest in the land. If he owns one unit in a multiply owned building or a site, he has no redevelopment potential himself. He only has development potential if he combines with the other owners and can show that he has done so, in which case we would have regard to that. So that is basically the fundamental thing. We're not saying that a single owner, if he can show that he has joined together with other owners and has a development proposal, that would be reflected in the value of his interest. But most of the single unit owners do not have such an arrangement. And I think it would be unfair and against the law and the statute, provisions of the statute, to compensate somebody beyond his entitlement and his actual so-called loss when we take the premises away for the public project.
或者咁
有人再 follow 有冇
一陣間
All right, you can follow up later because we have other members who would like to ask questions. Next, Mr. Ip Kwok Him. Thank you, Chairman. Well, I'd like to share this with you because, well, from what I've heard from the Deputy Director or the Deputy Secretary, well, taking single ownership as an example, and also the difference between single ownership and multiple ownership. Well, in urban renewal process, we have this urban renewal authority which plays an important role in urban renewal. So in planning and development, and if it's approved that the URA would take up the development process, then that would give rise to a situation whereby there might be problems. Because if you're talking about a single ownership case and compare it with a multiple ownership case, there would be differential treatment. And what's the difference? For the same building owned by one single owner, the amount of compensation offered to the single owner would be very low. But then for the building with multiple ownership, well, very often the amount of compensation would be a lot higher than that offered to the single owner. Because very often, if you look at the compensation offered in urban renewal cases, the owners, the tenants, there are different, and if it's a owner-occupier, then the compensation that he can get would be somewhat different from a unit which is partly let and partly self-occupied. So the value would be very different. So from what I've heard just now, you said that you would be looking at the entire building and you would look at its redevelopment value as the basis for compensation. I don't think that should be the case because, well, in an urban renewal case, you would have to apply the URA ordinance. So in fact, they would not be able to get compensation up to the value of the building. All right, I heard about a case of a 4-story building, and each unit would cost about $5 million. So when you try to resume the building, you won't be able to do it. And for people living in those units, so you will have to offer tens of millions of dollars to them before you can resume the units. So why have we got such cases? Is it that after redevelopment, the URA does not have to follow the practice for single ownership cases? Have I expressed myself clearly? All right, Deputy Secretary, I think what Mr. Ip was referring to was urban renewal cases. So for the policy and the measures for compensation, so can you explain a bit more about that? Because just now, we might be talking about cases involving the land resumption ordinance. So that's the compensation mechanism under the LRO. But then what Mr. Ip was referring to was urban renewal cases, in particular where residential units are involved. So can you explain a bit more about that? Because if you look at the calculation, if you look at the compensation, the amount of compensation obtained by the owner under the LRO might be somewhat less. So Mr. Mills might be able to offer more information. Yes, Tony? Thank you, Mr. Ip, for your question. I think what you're referring to is the allowance for self-occupier or owner-occupier. So that's the 7-year rule. So that's not a statutory compensation, because when it comes to statutory compensation, we always refer to the open market value. But then when the URA resumes land for redevelopment, well, even for government resuming land, that would also trigger the allowance for owner-occupiers. So for the 7-year rule, is that a statutory compensation or is it a policy decision? Can you clarify that? Well, for the 7-year rule, well, that's the that's an allowance. So that's not what is offered under Cap 124, the LRO. So that's the additional allowance offered by the administration to the owners who are occupying the units. All right. I'm trying to extend this to the LRO cases, because in those cases you're also resuming the land, but then at the same time you're offering something additional to the owners. Because well, in this council I was one of those who raised our hands to pass the legislation. Well, for the well, that was in 2010 through the FC we got the funding support from the FC for the grant of this allowance, and that was approved by this council. That's not part of the legislation. Let me explain a bit further. Well, on the 7-year rule, well, for owner-occupier, the 7-year rule applies, but then for those tenants, that would be reduced by half. So the situation that you refer to was for owner-occupiers. I think what happens is, if you follow the allowance, then the amount that one can get would be somewhat more than what a single owner would be able to get. Well, why is it the case? Because they would not be able to buy a replacement unit. So why are you not following the mechanism under the LRO, so that when you assess the compensation to be offered to the single owner, you would apply the same rules? Well, in the example that I just cited, apparently differential approaches have been adopted. Mr. Tony, well, I'll wait until after Mr. Tony Chair has asked questions. 2 groups of questions. First, on mediation. According to my understanding, in the paper, para 12, well, in the English version, what it says here, well, as the subject or controversy often involves the interpretation and application of legal principles. That's why it's not appropriate to submit those cases to mediation. Well, in fact, the court would often impose mediation on parties to a litigation. So so very often that would involve legal principles, and if that's the reason given for not applying this or not submitting the cases to mediation, then I don't think it's appropriate. So I'd like to listen to the response by the administration more, because in particular we do encourage parties to any litigation to go through this mediation before settling the case before the court. That would save a lot of time and a lot of difficulties in such cases. So why is it that the administration has adopted this stringent approach? So even if you do not resort to mediation, you should not have banned it altogether. And there are two members who have asked a similar question. That's about the difference between RDV and EUV. I understand that when it comes to compensation, the administration would like to come up with a more stringent mechanism, which is clearer, and you would also lock the amount of compensation to be offered instead of having to exercise discretion all the times. Well, from the executive perspective, I can understand it, but then from the perspective of justice, in particular, many small citizens and small owners, they would think that their individual rights have been compromised because when there are large developers trying to buy up the units, they would be sacrificed. And of course, I understand that the principle of equivalence and also the equity law would also be applied. But then apparently, you are slanted too much in favor of the rules instead of giving more consideration to justice. And therefore, my initial consideration is, well, can you have a clawback situation whereby after certain time, if indeed because of the resumption, the entire lot has seen an appreciation in value, but then for the individual owners, if they are not able to get that compensation, but then after a certain time, if they are allowed to have a review of the case so that the individual owners would not lose all the rights that they are entitled to if justice is served. So can that be done? Mediation. Yes, on mediation, Chairman. Well, in making claims, under Cap 124, the process from the time of making the claim, well, the Lands Department would then communicate with the former owner, and then in that process, professionals would also be involved, and the professionals' fees under the law would also be reimbursed if it's reasonable. So that would already involve some form of discussion and mediation, but then that would not be subjected to the provisions of the law. But then what about mediation, which is deemed to be fair and just? So the Lands Department would say that, all right, I'll talk to you and see what can be done about it. So that would be somewhat different because, well, that would be very different from a mediation process. Indeed, the existing mechanism would not allow for a mediator to be involved. All right, they can get someone who is independent from the Lands Department. They can even get several professionals. Some of them might be surveyors or lawyers or even accountants, depending on the merits of the case. So the professionals can give their advice, and then that would be considered by the Lands Department before negotiating with the former owner. And of course, that might not be able to address the concerns raised by Mr. Chair. That is, they might not be able to exactly play the role of a mediator, but then the framework is there. So you will have to amend the legislation then. It depends, depending on the merits of the case. As Mr. Mills said just now, if the case warrants, if there is sufficient room for reaching a consensus without affecting the powers given under the law, then we do not rule the possibility of resorting to mediation. And indeed, there are some cases which are still underway, and it depends on the information furnished by the former owner. My understanding is that we have not yet collected all the information, and after the information has been collected, then we will have to discuss with the Lands Department to see if we would go for mediation. So we have an open mind on that. But then indeed, we have not made that attempt before. So we are not sure about the outcome. And at this stage, since we have not yet had any previous cases dealt with through mediation, that's why we cannot say categorically that we would go for mediation for all cases. At this stage, we believe that we will have to look at it on a case-by-case basis. Okay. What about clawbacks? Well, you will have to wait for the second round because you have overrun on your time already. Next, Mr. Wu Chi-Wai, also 4 minutes, including both questions and answers. Thank you, Mr. Chairman. Listening to what has been said, well, under CAP 124, you've applied 2 principles. Number 1, you look at the redevelopment value, and that would be offered to the single owner. But then if there is multiple ownership, then you would look at the open market value as the calculation basis. But then if the case goes to the URA, then generally speaking, you would offer an additional allowance for owner-occupiers. So in other words, if there are owner-occupiers, or if the owner is occupying part of the unit, then they will get additional allowance. So would that affect the redevelopment value? Does that mean that the redevelopment value has already been reflected in that? And through different allowances, if the redevelopment value has been fully reflected, then when we set out such compensation arrangements, should we also set it out very clearly? Because in the district, we often come across cases of the government calculating the compensation for the owners, and they think that they have been aggrieved, so they have not been fairly treated. But then, if you're able to tell us exactly whether the actual offer is already equivalent to the redevelopment value, then would it be better?
You have so many items of allowances. I think the effect is to make the actual value of compensation to be close to the RDV. Am I correct in this? So the RDV has been taken into account through various ways of calculation to let the owners feel that they have been treated fairly. I think there is nothing in CAP 124 to say that a single owner will be compensated according to the RDV. Yes, even in CAP 124, the open market value and also the principles for valuation are set out. There is no separate treatment of RDV, and also different 4 categories for single owners and fragmented ownership, distributed ownership. There are principles for compensation. You asked about the compensation process. It's true that in the valuation process, the RDV would be considered. If yes, then the market value may be higher, and therefore the proposed compensation by the Lands Department will be higher than the EUV. It's not that CAP 124 use RDV as a concept. Of course, I understand that the law won't be that detailed, but according to your paper, for a single owner building, I think it's under Section 12D, the value of the land resumed should be taken to be the amount which land, if sold by a willing seller in the open market, might be expected to realize. And it will be compared against the RDV, and the higher shall prevail. But if it is it depends on the value it can get by selling at the market. I'll try, and colleagues can supplement. In the land resumption process under Cap 124, the open market value is the starting point. And if we have a case where the property is held by a single owner, well, because there is a lot of room for property owned by a single owner to be redeveloped, and so we take into account the possible LTV. So when the entire property is held by one single owner, we work out the LTV as well, and the higher will be the compensation. And if it is distributed ownership, then we also use the open market value as the starting point. But we then work out the LTV, then will be based on whether there is evidence to substantiate to support the possibility of redevelopment. So that's why for some cases, if there's sufficient evidence that there might be redevelopment, then the Lands Department will work out an LTV as well. And the higher will be the proposed compensation. Mr. Yip Kwok Him. I think Mr. Mo Yong's understanding is correct. It's also the decision of the Finance Committee. Now for Cap 124. Does that mean, in fact, does that mean that the owners cannot have a share in the LTV? It will be entirely enjoyed by the URA. So it is not fair to a single owner owning the entire property. So how do you strike a balance here? But if the entire property is held by a single owner, there is the potential for redevelopment. But as explained by the administration, there are cases where the LTV may not necessarily be higher than the EUV. So can you respond, Mr. Mo Yong? Thank you, Mr. Yip, for your question. Well, the compensation criteria is the open market value. Please don't treat it as a case of land resumption, because we are required by law to evaluate the property value. Now, if the owner would like to work out the LTV of the entire property, a normal person will not be willing to offer that price. So I will first consider whether there is any possibility of redevelopment. Now, if the entire property is held by a single owner, the owner may say that I can get more by redevelopment. Are you willing to pay me the LTV? Regarding the allowance for acquiring another property, well, in fact, it is a resettlement policy or reprovisioning policy. The idea is to facilitate the owner to acquire a property of 7 years old or under, or to acquire property at 7 years old in the same vicinity. The idea is to take care of his housing need. Any follow-up, Mr. Ip?
I don't think I'm convinced. He's just explaining the current policy to me. Mr. John Z. Whether we talk about the measures, the special measures, or other cases, we have seen ex gratia payment or extra compensation. Perhaps there can be there is no the potential of redevelopment is not confirmed when it comes to valuation, but that may happen a few years after land resumption, and property owners may feel that they are not being treated fairly. So can there be a retrospective clawback so that the property owners will not feel that they've been shortchanged by government departments or large developers when it comes to compensation? They will not feel aggrieved. Mr. C, you assume that after redevelopment, the property has inflated in price. For instance, a flat in Tai Shing has no chance of redevelopment now, but what if 3 years after resumption, Tai Shing is redeveloped? Then can a retrospective clawback be given to the original owner? Because at the point of valuation, there isn't sufficient evidence to show that there is any chance of development and redevelopment, yet it happens a few years afterwards. The planning department approves a change in the OEZP, and or perhaps after acquisition, redevelopment does take place. Is there a possibility of giving a retrospective clawback to the owners affected? The calculation is based on the current status of the flat or the land. This is the framework. And as mentioned by Mr. Mills, for the sake of fairness, because the transaction takes place at a particular point and the valuation is done on that basis, if a few years afterwards we go back and work out the discrepancy, this is a bit difficult. Because land is resumed for public projects, for instance, and valuation is done at that point. We have never given retrospective clawback afterwards. Now, if it is for redevelopment, you can waive the owner from special stamp duty. Now, if a few years afterwards there is a big discrepancy in value, you should do something to address that injustice. So can you consider this possibility as a matter of policy to address this injustice? So would it only happen when there is inflation in value? Of course, when the value is inflated. With the passage of time, the situation may be clearer, but there is no prediction as to whether the market will go up or down. Mr. Mo Yung, can you supplement? But what if a few years afterwards it's found that the value has gone down? We will not ask the property owners to pay us the discrepancy in price. The date for a valuation is fixed. And that's the problem. When it comes to compensation, it may take time, and yet a valuation is pegged to a certain date. So what is the government's policy? In addition to the legal framework we have, I also understand that this is a principle under common law. Perhaps Mr. Mills can supplement.
I'd just like to, thank you, Celine. I'd just like to point out that the whole basis of resumption in accordance with the statutory requirements is the open market value at the date of resumption. I think, as Chairman, you just pointed out, it is a fixed date valuation. And once we start retrospectively looking back and paying out extra later, you can imagine how do you devise such a system which is fair and manageable. I really don't see how you can do it. And the principle is something similar. What happens if I sell my flat today and the market increases by 50% in years to come? Why should I expect to get that 50%? I'm selling it today at the value that it's at today in accordance with the lease restrictions. So the principle doesn't seem to be fair either.
係
Okay. Mr. Him, 3 minutes. Regarding Mr. Mills' views, you should look at the value at that moment, the fixed on the fixed date, right? If I have dealt with cases when the URA cannot look at the EVU. It paid out compensation to owners according to the home purchase allowance. The URA cannot operate according to Cap 124. It has to follow the URA ordinance. That is to acquire a property in the vicinity 7 years old. Is it true that URA has no right to act according to Cap 124? Or is it just that URA has not followed Cap 124? How can you ensure that justice is done for the property owners? Which one? From the administration? Mr. Moyo? I don't think I quite get Mr. Yip's question. The URA will not resume or acquire properties according or under Cap 124. It has got its own acquisition policy. When it has come to an agreement with property owners, then we'll ask the administration to do it under Cap 124, and the criteria there would be used. Whether it's the administration or the URA, they give a home purchase allowance for buying a property of 7 years old in the same neighborhood. So if URA cannot acquire the required percentage of shares, it can only ask for compulsory sale, and then the government will have to use Cap 124 for that purpose, right? Yes, URA has to negotiate with property owners, and if the latter refuse, then Cap 124 and also powers given to the URA will be invoked for land resumption. Mr. Wu Chi-wai, 3 minutes. Okay. I'll be very quick. According to the Lands Department's reply, you use fair open market value as the basis, whether it is whether there is a single ownership or divided ownership. It's just that if the entire property is held by a single owner, you believe that there is a greater chance of redevelopment, and therefore almost automatically you consider the LTV and to allow the owner to consider. If ownership is divided, you have doubts as to whether redevelopment can take place. However, if they can give you sufficient evidence to prove that redevelopment is possible, then you will take into account the LTV. Am I correct? If I am, then I have this question. Whether a lot can be redeveloped has everything or is related to the location of the lot. I'm sure you all know old districts in town. You know the situation. In an old district, I think there is an expectation for redevelopment. It may be difficult, but once a Cap 124 is invoked for resumption, then the RDV will automatically appear.
Because as the redevelopment is in progress, whether or not an agreement is reached or not, there is such a prospect. And also, if the whole district will be redeveloped, then it's not just about a single owner or multiple owners. So I think the first criterion is to consider whether the whole district will be subject to redevelopment or revitalization. I think we should adopt this whole concept as far as urban districts are concerned, whether there is a basis for redevelopment. Instead of adopting the contrary mechanism of letting the owner prove whether there is evidence that the building or the property will be redeveloped. I think Mr. Mill just now referred to the legal aspect of things. He talked about a scheme. Without such a scheme, the law doesn't take into account these matters. Well, you talked about the older districts being redeveloped sooner or later, and you say that you can rely on the law to say that there is prospect for redevelopment. However, as far as the calculation of compensation is concerned, it should not be taken into account. Perhaps somebody can supplement?
The effect of the scheme, whether it should be taken into account when assessing the compensation.
It's completely been ruled out by the court judgments. It's something that is a given. We have no, even if we wanted to, we have no flexibility. The court has ruled such that we don't take into account the scheme. And in fact, it's in the statutory provisions as well. It's very clearly stated.
Okay.
So the provisions already state that there can't be any flexibility. And there are case laws on that too. Next, Mr. Paul Chair, 3 minutes. A very quick one. I'd like to respond to the government's example. Well, of course, if you sell a flat now and if the price drops in the future, you cannot ask for compensation. But I'm talking about a voluntary transaction. I mean, that was a case of voluntary transaction, but I'm talking about compulsory acquisition by the government or resumption by the government. And I'm saying whether we should just strictly draw a line to give the assessed value as of the date when it is resumed, or when the value later on exceeds the assessed value, whether there could be flexibility. I don't know whether it's so pronounced, but I understand there is something called a Ponty Gold rule or principle. But now that there are complaints from the public, I wonder if the legal principle or the rule can be relaxed. Of course, as the executive arm, you may want to draw a line to avoid arguments, but I'm asking whether there is a way that could be more just. Anything to add, Ms. Choi? Now, on the legal principle, or the case laws, or our policy, or the process of land resumption, whether it's for public works projects, as Mr. Chair mentioned just now, it's correct to say that the transaction is not compulsory. In fact, the owner is required by law to so-called sell the land to the government. However, under the legal framework and under the common law principles, there must be a willing purchaser and a willing buyer and a seller, and which forms the basis for making the assessment. I'm sorry to interject, but in this council, we're not just talking about the existing laws. We're talking about future possibilities. That's why I ask whether we can fine-tune the approach so that we could do justice to the public. Well, still, land is resumed on a certain date, and we need a fixed value to be assessed in order to for the owner to accept that assessed value. I can only say that at this stage we do not intend to expand the range of dates from a date. All right, I think that we should more wrap up this item, Mr. Wu Chi-wai. I think today we have government officials responsible for the execution. And the electrical research team, however, has also done some research on other jurisdictions' practices on to see how other jurisdictions consider elements such as redevelopment value, so on and so forth. Now, the government's response is that, no, we can't make this comparison. Now, I have this suggestion. The Electrical Secretariat has made this observation. That is, other factors may be taken into account. In other jurisdictions, when it comes to land resumption, and if the government wants to challenge or query the electrical research team's information, perhaps you should give us some information. Or else it would be hard for us to accept your saying that it's not really comparable. Your saying is that property held under single ownership has a higher prospect of the redevelopment than property held under multiple ownership, and that's why in the former case the redevelopment value will be taken into account. But what we feel is that for a single owner, definitely he will be in a stronger position than individual owners in a divided ownership situation. And you also have the principle of equivalence, and it is the principle of the law to help the disadvantaged in order to strike a balance. It seems that the balance is now tipped. So I think the department, or perhaps the government, should reconsider if you're to query the discussion. I just want to point out that if you want to rebut the research team's argument, you need to put forward your justifications. Thank you.
有冇補充你嘛？政府方面
Anything to add?
I just like we don't necessarily rebut these papers. In fact, we find a lot of the information contained in the papers perfectly acceptable. and Hong Kong doesn't deviate on many fronts on the critical aspects of this subject. Hong Kong is quite in alignment, for example, with England and some of the other jurisdictions. So we don't rebut or reject these reports. We think they're based on sound research. We don't see the need to respond in any formal way. We don't feel aggrieved by the content of the report, and I think we're quite happy to leave it at that. But I think we have to also bear in mind from comments that we must respect the law, and it's the law that governs and controls much of what we do in this context of compensation and resumption.
好，呢項
All right, I think that's the end of this item. Nothing under AOB, so meeting's adjourned. Thank you.